Today, we are diving into a really fascinating legal case from the Northwest Territories. It's a story where one single mistake by police nearly brought an entire investigation crashing down. It's all about a key piece of evidence, a constitutional right, and a super tough call a judge had to make.
And it all starts with this number, $60,000. That's about how much cash the police discovered tucked away in a hotel room up in Inuvik.
Now, in the legal world, a big pile of cash like this isn't just, well, cash. It's seen as evidence, the potential profits from something illegal, and in this case, the suspicion was drug trafficking.
And this right here is the central question of the whole story. What happens when the police find rock-solid evidence, but they find it by breaking the rules, by violating someone's constitutional rights? Can they still use it in court?
Okay, so let's set the scene. It's March 2019. Police get a search warrant for a room at the Arctic Chalet Hotel in Inuvik. The search turns up the money, and that leads to the arrest of Omar, who gets charged with possessing the proceeds of crime.
But hold on, before police can ever get a search warrant, they have to build their case. They have to go to a judge with a big document, basically, laying out all the reasons they believe a crime happened and that they'll find evidence in that specific spot.
And here's how they did it, over just 3 days. It kicked off with a couple of anonymous tips about guys dealing cocaine from a blue Dodge Durango. Then police surveillance saw a known drug user get into that same truck. The very next day, an officer sees what looks like a classic hand-to-hand drug deal go down with the passenger.
So the main investigator, Constable Maine, he pulls all these threads together for the warrant application. He's got the anonymous tips, some info from a confidential informant, the hotel owner reporting some suspicious activity, his own surveillance, and one more really important piece of the puzzle, info they got from a traffic stop.
But it was that traffic stop, that seemingly routine stop conducted by another officer, was the one mistake that put the entire case in jeopardy.
And the key here is that the officer admitted it himself in court. He was completely honest about it. He said his only reason for pulling the car over wasn't for a traffic violation. It was to figure out who was inside to help the drug investigation. And that is a huge no-no. Police can't use their power to enforce traffic laws as an excuse to go fishing for information in another investigation. When they do that, it's considered an arbitrary detention, and that's a violation of Section 9 of our Charter of Rights and Freedoms. So this illegal stop created a domino effect for the judge looking at the case. Because the stop was illegal, any information that came from it was, well, tainted. The law is pretty clear. The police can't benefit from breaking the rules.
So here's the crucial part. The judge has to do this mental exercise. They have to look at the original warrant application and just delete everything that came from that illegal traffic stop. And when they did that, the whole thing fell apart. It was the traffic stop that gave them the driver's name and connected the truck to that specific hotel. Without it, there's no reason to search that room.
And if the warrant isn't valid, then the search of that hotel room is legally the same as if the police just kicked the door down with no warrant at all. That's a direct violation of Section 8 of the Charter, the part that protects all of us from unreasonable search and seizure.
Which brings us right back to our $60,000 question. The money is real, the evidence is solid, but it was found because of not one, but 2 charter violations. So what does the court do? Do you throw out the evidence to send a message about police conduct? Or do you allow it so the case can be decided on the facts?
To figure this out, judges use a special framework from the Supreme Court of Canada. It's called the Grant Test. Think of it like a balancing act, designed for exactly this kind of mess. It weighs our individual rights against society's interest in justice to see which way the scales tip. This test makes the judge look at 3 different things. First, how serious was the police misconduct? Were they being sloppy or were they willfully breaking the law? Second, what was the actual impact on the accused person's rights? Was it a minor blip or a major invasion? And third, what does society need here? Is it more important to see this case through or to uphold our charter rights?
So let's look at the judge's scorecard here. On the police conduct, the judge called it a middle to low range mistake, not done in bad faith. That pointed towards letting the evidence in. But the impact on the accused privacy, that was huge, a big checkmark for excluding the evidence. And finally, society's interest in having the case decided on the evidence, also very high, which pointed back towards letting it in. Let's break that down a bit more.
On that first factor, the judge basically said, look, the officer made a serious error. He should have known better. But it wasn't a willful and reckless disregard for the rules. He was honest about why he did it.
So, while it was bad, it wasn't so outrageous that the court needed to completely wash its hands of it.
But that second factor, that one weighed heavily in the other direction. The right to privacy in your home, even a temporary one like a hotel room, is one of the most important rights we have. A search without a proper warrant is a major intrusion on that right.
And finally, we have society's interest. That $60,000 is reliable physical evidence. If you exclude it, the prosecution's case completely evaporates. Poof, gone. And that would mean a very serious charge in a small northern community couldn't even be judged on its merits.
So you can see the tug of war here. You've got a significant violation of someone's rights pulling one way and society's interest in getting to the truth pulling the other. The judge had to weigh it all and make the final call.
And here's the decision, right from the judge's own pen. After balancing everything, the judge decided that, in this specific case, excluding the evidence would actually do more harm to the reputation of the justice system than admitting it. The evidence was in.
And that really gets to the core of what the Grant test is all about. It's not designed to punish the police for mistakes, and it's not designed to let someone off on a technicality. It's about one thing, making sure that, in the long run, the public continues to have confidence and trust in our justice system.
This case really shines a light on a fundamental tension baked right into our legal system. Here, the judge drew a line and decided admitting the evidence served justice best. But it leaves you with a really tough question to think about. Where is that line? And at what point does upholding our rights mean we have to be okay with letting crucial evidence just walk out the door?